All right, hello everyone, and welcome to another Hill Duvernay and Associates webcast. Very excited about tonight's topic. We are talking about the best interest of the child custody. And so this is another topic that a lot of people have questions on, especially because it's really important when anything is dealing with children.
Yes.
So want to introduce who we'll be speaking with today. So we have attorney Anyama Farrey, and then we also have attorney Candace Duvernay.
Hi, everybody.
Candace Hill Duvernay, excuse
Yes.
me, so you can understand she's managing partner. But if you just briefly want to introduce yourselves and kind of where your practice areas are, that would be great.
Sure. All right. Hi, everybody. Again, hopefully you all are tuning in again. It's not your first time, but I'm Candace Lynn Hill Duvernay. I'm the managing partner of Hill Duvernay and Associates, where we practice criminal defense, personal injury, and family law, which is why we're here today.
Hello. Thank you for having me once again. I certainly appreciate being here. My name is Anyama Farrey, and I am the managing attorney of Duvernay Associates. We are mainly a civil litigation firm. We handle a lot of family law cases, which include divorces, custody, child support issues. We handle criminal defense cases that we typically defer to Attorney Duvernay to handle for us. And then we also handle car accident and personal injury cases.
Yes. Well, excited again to have you here. And then lastly, my name is Nicole Carter, and I'm founder of Creative Flame Media, and I'm excited to always get to host these webcasts. So we're going to jump right in and start with the first question, and this is for you, Attorney Duvernay, which is, what are the types of custody?
That's a great question, and I know Anyama and myself, when people call, they say, I want custody of my child, and they don't always know what that means. Well, custody is determined in two ways. First, there is legal custody, which means you can make decisions regarding non-emergency health care. You can make decisions regarding extracurricular activities, religious choices, as well as other things. I forgot one.
Education.
I had them ready. Education. So that's legal custody. Then there's physical custody, which is where the child actually resides on a day-to-day basis. Custody, whether it's legal or physical, can be used jointly with both parents, where they have equal rights to being around the children, 50-50, or it can be split up however the courts deem fit. So sometimes that looks like 70-30, 60-40, 80-20, or sometimes 100%, just depending on what's in the best interest of the child. And that's the legal standard in Georgia. A lot of times parents come and say, well, I want this or I want that. But the best interest of the child is what we call this, is because that's what the courts are going to be looking at.
And one thing I'll add too, because you mentioned those primary areas that the court considers when determining legal custody. Sometimes parents don't always agree.
Right.
And most of the times that's why we're here. That's why they
Exactly.
hire us. And when they can't agree, the court has to decide who's going to be the final decision maker.
Right.
So when you are discussing those primary areas, like whether they're going to go to private school, public education, or are they going to be a Buddhist or a Muslim, or are they going to take penicillin or not, or undergo a type of surgery, or whether they're going to play soccer or the piano. Those type of decisions people come across all the time. And somebody has to be the final decision-making authority. So the person who actually has primary physical custody, meaning the person that actually has the children every single day, the children resides in the home, that person actually is the final decision maker. Because people don't realize that. So even if the court says, you know, there's going to be a joint legal custodialship type of arrangement, the primary physical custodian actually gets the final say-so.
Exactly.
And it just kind of makes sense because if your child is going to be residing with you every single day, it makes sense that you would be the one to determine which school he or she goes to. You know, because the other person deciding, you know what, they should go to school near my home doesn't make sense. And it wouldn't be in the best interest of the child to travel 45 minutes to go to school near mom or dad when they can go to school right down the street where they live primarily.
And sometimes, which is rare, but sometimes courts will split it up, and some parents will have the decision-making authority for, you know, education and extracurricular activities, where the other may have it for non-emergency health care and religion. So I know that's a lot to swallow, but when we're talking about what's in the best interest of the child, the court's going to be looking at all of those things.
Yeah, and that's a great point, because I actually had a case where the father was not the primary physical custodian, but essentially education was really important for him.
Right.
You know, he had a really strong education background. He went to Georgia Tech, had all of these degrees, and it was just very important. Whereas mom, you know, she wasn't really, I guess, education wasn't as strong or important to her. You know, she was more concerned with religion, believe it or not, because, you know, a lot of people are very serious about their religious beliefs and practices as far as the children are concerned. But dad really fought for that. And even though dad didn't have primary physical custody, that was something he was able to get.
Awesome.
And the court granted him, you know, that final decision-making say-so when it came to education. So that's a great point.
Thank you.
That's really interesting.
It's a lot, right?
That's a lot. You just kind of assume that things are tied together, but it can actually be split apart.
It
and you
can.
have to
It's the essence of co-parenting, and I always try to encourage people to co-parent and try to reach a resolution, because, you know, it's better that the parents are in control of their circumstances rather than having the courts decide what's in the best interest of children who don't even belong to, you know, to the court.
Exactly.
Okay. All right. Well, Attorney Farrey, this one's a follow-up for you then. So now we've talked about the types of custody. So how does the court determine child custody cases?
Well, it's not a straightforward process. I get that question all the time, because some people say, well, if I don't make a whole lot of money, is that going to hurt my chances of getting custody? Or she got arrested, you know, she got arrested for DUI. So does that mean I get custody? And I tell them it's not, you know, it's not the deciding factor. Like Attorney Duvernay mentioned, determining custody is based on what's in the best interest of the children. So it's about 17 different factors, you know, that are determined, and the court weighs all of those factors. And those factors, for example, would be the community that the parties live in. So let's say if the parties are already split and the child is used to growing up in Riverdale, Georgia, but then the parent seeking custody lives all the way in Noonan, Georgia, then the court's going to take that into consideration, because the less interruption to the child's environment, the court determines is better. Or another example would be, which parent is more likely to encourage a relationship with the other parent? You know, in situations like that, the parents don't always like each other. They don't always get along. And so the court will place the child with the parent who's more likely to speak encouraging words to the child and talk positive words to the child about the other parent, and actually foster that relationship more so than hold that child from seeing the other parent. Another determination is stability. You know, which parent has more job stability, which parent has more financial stability as far as being able to provide for the child. So, you know, when people call and say, well, I don't make a whole lot of money, can I still get custody? Yes, you can, but the court will weigh that factor. It doesn't mean that factor will be the deciding factor, but those factors altogether will be determined as far as what is in the best interest of the child. So it's complicated, but it's good to know, or people find relief in knowing that one certain blemish of their living situation is not the end all be all of their right to have custody.
That's exactly what I was thinking when you said, you know, 17 or so. I thought, whoa, that's a lot. But as you started talking, it's better just because it creates a more holistic decision-making process.
Exactly.
So that's really good.
And some factors may not apply to a person's circumstance. Like one factor is whether or not a parent has substance abuse, or whether there's been a history of domestic violence. And if that doesn't apply in your situation, then of course that's not a factor that the court would consider.
Okay. All right. All right. So we're going to bounce this next one to you, Candace.
I'm ready. I hope.
So if children are born out of wedlock, how does a father go about gaining custody?
That's awesome. I think we kind of touched on this in our last webcast about fathers who have to pay child support but have no right to their children. So now we can answer that question for you. In the state of Georgia, if a child is born out of wedlock, a father does not have any rights to that minor child. I know Attorney Farrey and I are like, oh my goodness. And even she has the billboards, fight for father's rights.
Father's rights.
Because mothers, they come out of the womb and they're automatically assumed to have all the rights, whether it's those things we talked about, legal custody, physical custody, the biological father doesn't have any rights in Georgia. So the child must be legitimated in Georgia. And that's an actual legal process. A lot of times people think, well, I signed the birth certificate, or there are other forms that people sign, which are acknowledgments of paternity, which says, yeah, the baby's mine. He looks just like me. That's my baby, you know, but that is not going to give you a right to have custody or visitation. And so a lot of what we do is not just necessarily with divorced parents. It's parents who have never been married, but there are fathers who want to have rights to visit with their children. And let me say this, and Attorney Farrey can correct me if I'm wrong, just because you legitimate, you still have to go through and show why you should be giving custody and visitation. So legitimation just gives you the right to ask for it, which is crazy. So you jump through hoop number one, and you still have to jump through another hoop to actually get custody and visitation.
And that is correct. You're absolutely correct. And a lot of fathers aren't familiar with this law because other states don't have them, you know. And, well, let me not say other states. Some states may have similar laws, but essentially in Georgia, we're in the South, we're in the Bible Belt.
Right.
So our laws are structured to encourage marital relationships. You know, Georgia likes families together and marriages. So that's why we have this legitimation law, and it requires, because the presumption is that, you know, when you're not married, anybody can be the father. That's the presumption that Georgia law has. So essentially, when a child is born between two people who aren't married, like you mentioned, just because they signed a birth certificate, just because they signed a form at the hospital, the acknowledgement of paternity, doesn't necessarily mean they have custodial rights, unfortunately. So you do have to come see us and actually have us file a petition for legitimation. And it is a two-step process. You know, that first process is, should this person be legitimated? Meaning, should you be deemed the legal and biological father of this child? And once the court determines yes or no, then the court then determines what type of custodial arrangement or visitation arrangement will you have. And then at that point, the court can say, you know what, even though you're legitimated, I've deemed you to be the legal and biological father, you're still not going to have custody.
Right.
I'm going to give custody entirely to mom. Had the child for 16 years, and dad has waited 16 years to file the legitimation.
Thank you. I was about to say that.
Or there's been, maybe dad has shown a history, or maybe dad has shown a history of not making really good decisions for the child. You know, that can come into play as well. But the court may also award or grant visitation as well. The visitation, you know, it could have some restrictions on it. The judge may say, you know what, I'll give you this visitation, but it has to be supervised because you have a violent history. Or it has to be supervised because the baby is 6 months, and the baby being away from the mother at 6 months, you may need some assistance with caring for a young infant. So it's different circumstances that the court considers. Every case is different, but you certainly have that two-part test that essentially you have to go through.
And I'm glad you mentioned about the length of time, because a lot of times we're finding now, a lot of fathers don't know. Some of you may have never heard the fact that you have to legitimate your child, but you see your child every weekend, you know, and we have those fathers who are now, because the baby's mother, or vice versa, the baby's mother said, I want to have my child and I'm getting married, or this or that. Now they can't see their child, and they're like, what? This is my baby. And not only do I pay child support, I take him to baseball, I buy his cleats, you know, I do all these different things. And so we have seen fathers not know this information and come to us, their baby's 5, their son is in middle school. And don't let that scare you off, because courts can still grant legitimation later on if we can establish that you've been in the lives.
Right.
For our mothers out there who may be terrified that the baby daddy hasn't been there forever and they're going to come knocking on the door at 16, we also can argue that in the other way. Well, he's not been here. Why should he be legitimated at this point?
Right. And one other, it's interesting that you use that as an example, because I actually had a case where dad actually had literally physical, now not through the courts, dad had physical custody of his son, but he had never been legitimated. And his son lived with him. I think he was 14 when he came to see me. The son was 14 years old. And the reason why he decided to file for legitimation, because quite naturally he wasn't thinking about that. I mean, he had custody, he was taking care of him, he sees him every day, he provides for him. So he wasn't thinking, maybe I should file legitimation. But he ran into an issue with the high school. You know, when he wanted to enroll the son in high school, the school said, well, we need proof that you're the legal father. You know, so it wasn't enough for him to just have the birth certificate. And he actually had, I think, actually what it was, he didn't have the birth certificate. He didn't have the social security card. He knew the information, but he didn't have those necessary documents to enroll his son in high school. But the mom did.
Right.
And of course, mom, you know, required him to jump through some hoops to get that information. So at that point, he decided, you know what, let me go ahead and establish my rights. Because when you establish your rights through the legitimation laws and you establish your custodial rights, then you do have free access and equal access to those information in that document.
Exactly.
So the school gave him a hard time, and they stated, well, unless we have some sort of legal documentation through the court, you can't enroll your son. So can you imagine the panic and you know the frustration that he went through only a few weeks before school was started?
Right.
So I always tell people, it may sound crazy and you may think, you know what, it's a waste of time, I don't need to do it. But I always tell my fathers, look, even if your child lives with you, even if you and the mom live together, go ahead and be legitimated.
Right.
Because when you go, and it's always nice to go through that process when both parties get along.
Yes.
Because
so much easier.
They can sign off on everything.
Exactly.
So even if you live with your child and you live with your child's mother, y'all are in a relationship, but you're not married and you don't plan on marrying anytime soon, go ahead and reach an agreement with a legitimation and file those papers. Because at least if things go south, you're covered.
That's
you have your
advice.
established rights, you have your visitation in place, and then later on you can establish child support. But at that moment, when they're living with you, you don't have to pay child support. So just legitimate. Or put a ring on it. Put a ring on it.
I love it.
So,
You have options.
You have options. You have lots of options. I love it.
All right.
That's really good.
Perfect. All right, so Anyam, I'm going to follow up with another question for you then. What happens with, how is child custody handled when there is a parent that lives outside of the state, or say they're in the military and for long periods of time, you know, maybe traveling or things of that nature?
Well, that certainly, it is relevant. Because remember those 17 factors that I mentioned, that's something the court will take into consideration, you know, the location. So if you are living out of state and the child, let's say you're living in California and the child is living in Georgia, grew up in Georgia, and you're a dad in California and you're wanting custody of your child who lives in Georgia, the court is going to weigh that factor and determine whether or not it's in the best interest of the child to actually be in dad's custody in a completely different environment, hundreds of miles away, states away, 3 different time zones away, and actually determine whether or not that's going to be in the child's best interest. You know, especially if the child has other siblings, or if the child has an established reputation in the community. Maybe they're involved in soccer, involved in different extracurricular activities. To uproot that child and have that child go miles and miles away, the court will kind of take that into consideration. But I will say, if you're not looking for primary custody, but you may live out of state or you want to move out of state, you can still establish your legal custodial rights, meaning you still have a joint say-so in what happens with your child with the extracurricular, healthcare, education, and religion. You still have a say-so. That doesn't change. It's the physical custody that becomes an issue if you're out of state. But if you're not seeking physical custody, you still have a right to what we call parenting time, otherwise known as visitation, is what most people call it. So essentially, you still have that entitled time with your child. It just may be adjusted to fit your circumstances. So instead of the every other weekend or every week or every other week, it may be just major holidays, or maybe school breaks, or maybe a significant period during the summer. So it just varies. But again, that's something the court does take into consideration.
All right, so then, Candace, this one's for you. I'm going to tie it in just a little bit, but you can go broader. So say I'm a child and I'm in Georgia and my parent is in California. Do I have a right to decide where I want to live if, for example, I want to live with that parent in California?
So that's a very good question, and we often see that a lot. We have parents come in with 4-year-olds. Who you want to live with? Dada, you know. Parents are often bringing their children in to these custody issues. So the answer to your question is, in Georgia, at the age of 11, the courts may consider as one of those factors, those 17 factors, whether or not the child's election should be considered. Now, at the age of 11, that's not a very strong factor. It's just one of the many factors that the courts will look at. At the age of 14, however, the courts looked at that a lot stronger. It used to be that At 14, whatever the child says goes, and that's a wrap. Now, the courts have recently, or the laws have recently changed where that 14-year-old's choice can be questioned by the courts. We would call it a rebuttable presumption. The presumption is that the courts will put you where you want to live at 14 or older. But you can rebut that if we find out that that parent is unfit, that parent is on drugs, that parent is flying here and there and everywhere. It's never at home. The parent bought you a car and is sitting in the garage until you turn 16 if you make that choice, you know.
Right.
And believe it or not, we do see children who are being bribed to say they want to live with their parents, especially at 14. If you remember at 14, we were here today, gone tomorrow, you know, with our emotions. And so the courts are going to be looking at that a lot more closely than they had been in years previously. So if a child is 15 years old and they want to move to California with mom or dad, and they say, I really want to move because my mom has been a great parent to me. I really feel like it would be great to have a new lease on life. I'm not getting far in school here. I'm getting in a lot of trouble. I'm getting bullied. You know, a court may say, wow, go ahead and go. You know, but if the child is like, well, you know, my mom let me do whatever I want to do, you know, or if Attorney Farrey can establish that that's why they want to do that, then the judge may say, you know, I'm not going to do that. So the answer is not as cut and dry as it once was.
Right. It's not. You're correct. I actually had a case recently where the child was 14. And the child actually did want to live with dad. And I represented dad, and dad stayed thousands of miles away on the other side of the country, essentially. And, you know, we went to trial, and, you know, the court did weigh all of those factors that we mentioned. And ultimately, the court did defer to the 14-year-old's choice. You know, even though it's going to be thousands of miles away and it was on a completely different coast, the court went ahead and honored his decision because the other side wasn't able to prove that my client was unfit.
Exactly.
You know, so that's the rebuttable presumption. If you can prove that the other parent is not fit to care for the child, then essentially the court, although we'll consider the 14-year-old's election, does not have to abide by that election.
Which is honestly a good safeguard because, like I said, I have seen, I'm sure you have, where these teenagers are mad at their parent. And literally just because they're mad, they're like, well, I got in trouble, I want to go live with my dad. And because a lot of times, as you said, these parents don't get along, this is another opportunity to get in the side of the mom and just kind of nitpick at her. So I like the fact that the laws have changed slightly to give the courts a little more leeway in saying, well, no, you know, that's not fit for you to be there.
Right.
Absolutely.
Good point.
Definitely. Okay, so Attorney Farrey, then talked about the kids. Let's go to the other end of the spectrum. Let's talk about grandparents. So do grandparents have any rights when it comes to child custody?
And I get that a lot too. That's a great question because you have grandparents who sometimes assume the role as parents, you know, maybe because their children are not ready, you know, to be parents, or simply their children need assistance in raising their own children. So with grandparents, they don't have an automatic right to custody, you know, not in Georgia. Essentially, if they want to establish any type of custodial rights, they will have to go through the courts. Now, it depends on the circumstances and the situation because they could vary. For example, let's say if a parent, you know, God forbid a parent was in an accident or something, and they're a single parent and the other parent is nowhere to be found, but they need someone to care for not only them, but their child, then they could go through the courts and, you know, ask for a temporary guardianship of the child, a permanent guardianship. Or let's say my colleague had a situation where both parents actually died and the grandparent wanted to step into the picture and actually wanted to adopt the child. So they can file a petition to adopt the child at that point and take care of the child as opposed to the child going into any type of foster care or into the custody of the state. Or you may have a situation where, let's say if I've had this situation too, where the grandparents didn't think that the parents were fit. You know, she didn't think her son was fit to provide for the child, and the son didn't really have an interest. And mom was on drugs, you know, as well. So in that situation, the grandparents can petition the court for custody of the child. But I will say it's very difficult because it's a really high standard, because when grandparents step into the situation and try to gain custody of a child that's not biologically their child, the standard is higher. They have to prove by clear and convincing evidence that they're entitled to custody and that the two biological parents are not entitled to custody or maybe not fit to have custody of the child. So it's very difficult to gain custody, especially if the parents are disputing it or objecting to it. But I will say the rights that grandparents do have to petition the court is grandparents' visitation. That's certainly a right that grandparents can have. I've handled those cases as well. With grandparents' visitation, what you're saying is, I have so much involvement in my grandchild's life that to remove me or not give me a regular parenting time to see my grandchild is going to harm my grandchild. Because like I said, some grandchildren are very close to their grandparents. And so if you can prove that you've been very involved in your grandchild's life, that you care for them, you have an established love and bond with that child, then the court may deem it in the child's best interest to maintain a certain schedule with the child. And in the past, it varies. It's been I've had grandparents visit with their children for maybe 1 weekend a month, because you have to keep in mind the other two parents need time with their children too.
Right.
So maybe 1 weekend a month every year, and then maybe like a full week during the summer so they can go on vacation.
Okay. Right.
And one thing about grandparents, a lot of times if you do have grandparents that are stepping in voluntarily and all parents are involved, it may be good to go ahead and get a temporary guardianship, because when it comes down to school or government assistance, I had to help one of my family members do that for minor children. They had been taking care of them because the parents weren't doing their job. But when it came that time for grandparent to get some assistance, there was none to be had. And so parents can do a temporary guardianship, which is a little different than what we're talking about.
Right.
It's a different court, it's a different process, but that may be an option for grandparents who want to help their children out and still be able to have, some actual say-so over their grandchildren.
Right, but they may not be able to meet that custody threshold.
Exactly. So you may not be able to, exactly. That's exactly what you may want to look into.
Right.
Okay, that's good to know. Yeah. All right, so I've got my last question that I'll open up, and then you're free to anything we didn't hit that you want, viewers to know about. But the question, Attorney Farrey, is for you: how does custody affect child support?
Well, it's not an automatic effect, meaning that just because you get custody doesn't mean it's going to automatically reduce your child support or even increase your child support. But it does play a factor in certain circumstances. One factor would be, let's say if you both have joint physical custody, meaning that your child lives with you 50% of the time. Now, there are 365 days in a year, so it's kind of hard for it to be
exactly
right, unless you split that one day.
Exactly.
Then maybe it could be 50-50. So it's a little difficult, but let's say that, majority of the time, almost 50% of the time your child lives with you, then essentially what you can ask the court to do is to reduce your child support and give you what is called a parenting time deviation. Because there are several different bases that a court can use to reduce the child support. So if you have a joint physical custody situation, and it truly is a joint physical custody situation, then you can ask the court to reduce your child support. Now, I will say it doesn't always eliminate child support. It's a possibility. It really just depends on the parent's income. Because the child support laws do take into consideration both parents' income. So if you have two parents, for example, let's say one parent's making $2,000 and the other $2,000 a month, and the other parent is making $10,000 a month, and the child is spending almost 50-50 amount of time with the parents because they have a joint physical custody type of arrangement, most likely your child support won't be eliminated completely because of the disparity in the incomes, but you can ask the court to reduce your child support obligation because of the amount of time that you spend with your child. I've had people who would have arrangements or joint physical arrangements, where the summer, the entire 3 months during the summer, the child is with them. So, it's kind of difficult, fathers and mothers, depending on who's paying the child support, but it's kind of difficult for a parent to fork over $800 a month during the summer, knowing that the children aren't there. So the children are sitting right there on your couch and you're paying the other parent $800 a month. So, that's kind of difficult, but essentially, let's say both parents are making $2,000 a month, and they both have equal joint physical custody of the child, then in that situation, your child support obligation will most likely resort to zero. You know, because essentially when you put in income for mom and income for dad and you equal out the time, it may just about equal to zero. Well, in theory, it would be, let's say mom owes dad $300 a month. Dad owes mom $300 a month.
So it cancels each other.
So it cancels each other out. So there is a child support obligation, but because of the amount, it cancels each other out, and then there is no child support paid. But that's why it's important to, hire an attorney to assist you in that circumstance, because deviations are discretionary, meaning that just because you decide or you agree to a joint physical type of arrangement, it doesn't mean that the court has to grant you that deviation based on your parenting time. The court can again weigh those factors and determine what's in the child's best interest. So I will say it's difficult to have that parenting time deviation. But I've been able to achieve that.
We have done it.
I've been able to achieve that in a lot of my cases.
Yeah. One thing I want to add about that, if I may, is that be mindful of coming and doing a modification of custody just for that reason. Because I have seen courts see right through it. And if you want to anger a judge, put the child in the middle of a money match, Now, granted, a lot of times those people were not represented, but if you're talking about custody, courts are going to be very mindful of why you're pursuing custody, Now, courts are also mindful of if you're paying this kind of money and you're not getting any kind of relief and you're still spending this kind of time, courts do want to give you a break, But we have also seen people who start visiting a lot more because they know that they're about to file these modifications. That's not the way to go. So just be mindful and just try to always operate with good, clean hands. It makes our job a lot easier.
That's a great advice.
Definitely. All right, so like I said, that's it for the questions that I had. But is there anything else, any other, tips or things that people should think about who are going through any child custody situations?
Well, I definitely just want to emphasize how important it is if you haven't established your custodial rights, maybe because you had a child or children out of wedlock, do so immediately. Definitely do so. And one thing I'll mention too, if you're married and perhaps going through a divorce, you don't have to establish your custodial rights because you're already on an equal playing field. So if you're married, that's a different story, although the court still has to make decisions with regards to legal custody and physical custody, but you don't have to go through that initial legitimation process to even get to that point. But I will say it's very, very important. It's so important that we have criminal laws against it. Well, not against custody, but essentially what happened is, let's say if a parent establishes their custodial rights. Let's use father, for example. And he establishes his custodial rights and he has joint legal custody and he has a set parenting time to spend time with the children. And let's say that mom decides, you know what, even though you're supposed to have the child this entire week, I'm not going to give you our child. I'm going to withhold our child, and so what? So essentially what dad can do is dad can file a complaint with his local sheriff's office, and it's called interference with custody. And it's a misdemeanor if you're found guilty of it. So any individual who interferes with another parent's lawful custodial right, they can be charged criminally with interference with custody. Or the more common example that people are more aware about is if a child flees or a parent flees the state with a child. So let's say the parent wants to get away from an ex-husband or ex-wife and decides to take the child and flee or kidnap the child, quote unquote. Essentially, that's deemed to be interference with custody. If it happens once or twice, you can get fined up to $1,000 and up to 5 months in jail. If it happens 3 times, then it's a felony, and you can face 1 to 5 years in prison. So courts aren't playing. Custody is very, very serious. So if you haven't established your custodial rights, make sure you do that because it will be protected under the law.
That's great. Awesome. Right.
I would just like to add the importance of always being mindful of what is in the best interest of your child.
Yes.
So if you establish a custody arrangement, we've seen people establish joint custody when the baby is 6 months. And that's easy because for 2 weeks, they're living with you in their crib. And in 2 weeks, they're living with me in their crib. But once school starts, and they actually have homework to do, and they have friends that they want to play with, they're packing a bag every other week. that's a lot harder for the children. The beautiful thing is Georgia law does allow for a modification of custody. So if you get into a custody situation that works for your children at one point that no longer works, do that immediately. Don't just take it among yourself and say, I'm not bringing him this weekend. He cry every time I drop him off. No, you cannot do that. Then you'll be hiring me to get you out of jail. Okay? So go through the right steps. I think the reason we do this is we want to arm you with the knowledge to know that you can take legal steps to do what's best for your children. Okay?
Right.
So don't feel like you're stuck. Don't feel like you're tied down. We're here to help you, and give us a call. Shoot us an email, send us a Facebook message. We got your back.
Exactly.
Love it.
Well said.
Yes,
Thank you.
it's definitely about being proactive versus having to be reactive.
Yes.
So, all right. So with that being said, Candace, if you want to wrap up and say how people can get in touch with you if they have more questions.
Sure. If you want to see myself or Attorney Farrey, because she is our of counsel, you can come to www.hillduvernay.com. You can also call us at 678-561-5529. Follow us on Facebook and Twitter and all that stuff as well.
Well, thank you both again. Thank you to our viewers for tuning in.
Thank you.
And we will see you next time.
All right.
Thanks.
Bye.
Bye.